Good morning, everyone. My name is Enrique Zúñiga, and I am the Executive Director of the Massachusetts Peace Officer Standards and Training Commission, commonly referred to as the POST Commission. Today is Tuesday, December 6th. Welcome to this virtual public hearing. This hearing is being recorded, and this hearing pertains to two sets of regulations proposed by the POST Commission. Joining us remotely are Commissioners Larry Calderon and Commissioner Larry Ellison. We're also joined by General Counsel Randy Ravitz and Deputy General Counsels Veronica Lightfoot and Pauline Nguyen, as well as Jamie Ennis, who is going to be providing technical assistance. The first proposed set of regulations would govern the Commission's databases and its dissemination of certain information. The Commission would adopt the set of these regulations as Chapter 8.00 of Title 555 of the Code of Massachusetts Regulations. By way of explanation, the Massachusetts general laws require the Commission to maintain a public database with certain forms of information concerning law enforcement officers. It further requires us to publish various materials on its website and to furnish certain records to members of the public upon request. But state law also requires the Commission to consider the health and safety of officers in developing its public database. It requires certain Commission information to be kept confidential and restricts state agencies from disclosing particular types of information, instruct agencies to correct inaccurate records, and describe certain precautions that agencies must take in maintaining data. The proposed regulations provide for the Commission to take various steps to ensure that, one, the Commission satisfies its obligation under the various laws. Two, facilitates the public's ability to obtain important information. And lastly, treats non-disclosable and inaccurate information appropriately. The second set of proposed regulations relate to the specialized certification of school resource officers. The Commission would promulgate those sets of regulation as Chapter 10.00 of Title 555 of the Code of Massachusetts Regulations. By way of explanation, the general laws authorize the Commission to issue a specialized certification for an individual acting or intending to act as a school resource officer. And they provide that, quote, a person shall not be appointed as a school resource officer unless specially certified as such, end quote. The proposed regulations establish requirements for this type of certification. They also set out procedures to be followed when an officer applies for such certification, when the Commission grants, conditions, or denies an application, and when an applicant seeks review of an adverse decision. At this hearing, we will receive oral comments concerning these two sets of proposed regulations from those of you who wish to offer them. For over a month, we have invited members of the public to request that they be placed on the speaker list for this hearing and to submit written comments on the proposed regulations. If you did not previously ask to be placed on the list, you may do so during this hearing by utilizing the question and answer function that is at the bottom of your screen. If you called in by telephone, you can signal your interest in speaking by pressing *9 on your phone. After these introductory remarks, we will call on those who have expressed interest in speaking. Please mute your audio when it is not your time to speak. We will unmute you when it is your time to offer comments. We ask that when it is your turn to speak, you begin by telling us your name and then proceed to offer your comments. Please limit your comments to approximately 5 minutes so that all who wish to be heard have an opportunity to speak. After we have called the names of everyone on the list, we will invite comments from anyone else who may wish to speak, but did not ask to do so previously. Please be aware that we are here to listen to your oral statements and will accept whatever written submissions you may wish to provide. But we are not here to answer any questions or discuss any comments you may make at this hearing. If you need technical assistance, please inform Jamie Ennis, who is part of the panelists in this session, and we will be happy to offer assistance. You can also raise your hand at the bottom of your screen in the reactions function of Zoom. We will continue accepting any written comments that you or others may wish to submit until 5 p.m. this afternoon. Instructions for submitting written comments may be found at the Commission website. If you're interested in commenting on matters other than proposed regulations that I have described here today, please send us a message with your full name and a summary of those comments by using the postc-comments@mass.gov mailbox. This address is also in our Commission's website. So with that, I will start giving people an opportunity who signed up, an opportunity to speak, those who signed up in the order that they signed up. So first we have Tracy O'Connell Novick from the Worcester School Committee. Attendees, if you want to raise your hand and be identified.
I see her on the attendee list. I'm about to transfer her in as a panelist.
Okay. There you are. Ms. O'Connell, you may unmute yourself and turn on the video if you desire to be seen. Otherwise, you can go ahead and speak.
Good morning. Thank you for taking my testimony. My name is Tracy O'Connell Novick, and I am a member of the Worcester School Committee. I should note that I speak only as a single member of the Worcester School Committee. I'm not speaking on behalf of all of my colleagues. Part of my reflection is based on the fact that, as some of you may be aware, the Worcester Public Schools this year moved to a school liaison model away from a school resource model. We no longer have police officers within the Worcester Public School buildings during the school day. I did just want to note, though I know that this is not directly under your purview, that first of all, all of this conversation continues to be predicated on what, in my view, is a faulty assumption that police officers belong in schools at all. That the national data is actually quite clear on what the impact of that has actually been on students, and it has not been positive. I also would note, and I will call this out later on within the regulation, that I continue to be concerned at the undermining of the policy authority of school committees in Massachusetts. Under Chapter 71, policy is under the purview of the school committee, not under the superintendent, certainly not under the purview of the chief of police, and having the decision-making authority shift to administrators away from the elected boards is, in my view, intensely problematic. Regarding the regulations, I would note that in 10.04, 1B, the individual serving as an officer is appointed by the chief of police. Again, I think that is a problematic appointing authority. I also would note that the list that is delineated there of providing law enforcement, promoting school safety and security services, and maintaining a positive school climate, the note is that all of those have to be being performed in order for the individual to be considered as performing that. I would note that perhaps in some circumstances, people are going to be performing only some of those duties and are going to still be effectively functioning as a school resource officer. I would ask that you look at that definition more closely. And in subsection 2, not being required to possess an SRO certification, so long as the individual is not representing themselves as one, that's a simple matter of naming. And I don't think that that's a good loophole for the commission to be leaving open like that. that is actually part of the issue that we have in fact run into in Worcester, where we are talking about a school liaison model, which effectively is more like neighborhood policing. And yet we would certainly regard the person as needing the same kind of training, and not necessarily simply being only within the purview that is delineated here. I could not find a place, and it may simply be that I'm not familiar with the sections of the M.G.L appropriate, where a cross-reference to the statewide database that I know the state is now keeping in terms of disciplinary matters for police officers is referenced. Given that we recently saw reporting out of Boston of someone who had faced disciplinary proceedings and then was actually serving as an SRO in another district, I would strongly urge that that be required in terms of something that had to happen. I would also note that in 10.06, section 1, the division may obtain and consider additional information. One of those is receipt of discipline, misconduct, and past performance. Given that you're talking about police officers who are going to actually be within a school district, I would urge you to make that not conditional. It seems to me that that should be required. I would likewise note the notion of a conditional SRO certification. If it's a question of timing, I understand that particularly around the pandemic, we are all facing those kinds of things. That's one thing. But in other cases, it's a lack of information being provided. To me, that seems, again, intensely problematic if there's actually a lack of a paper trail or something of the like that the commission may not have. I also would recommend, and again, this may be someplace that I just simply didn't see it, that the certification be a matter of public record, much in the way that teacher licensure is actually something that people can actually go look and confirm for themselves. I know that it would be particularly reassuring to parents, to educators, and to students if that was something that was actually something that could be available to the public for reference. And that is the close of my remarks. Thank you very much for taking them.
Thank you, Ms. O'Connell-Novick. Thank you very much for your testimony. I may have missed this when you started, but if you're providing written comments to us in addition to what you provided orally.
I was not, but I certainly can.
I was particularly interested in the data that you referenced, the national data. Any reference to that effect, I think, would be very helpful to the.
All right, I will make a note of that and I will send it along to you. Thank you very much for asking.
Yeah, thank you much. Okay. Next, we have Marlies Spaniard. I'm sorry if I mispronounced that name, from CPCS. If you're in attendance, you want to provide testimony at this time, you want to signify so by raising your hand. There you are. Jamie, you will bring her in, right? Just give us a minute, ma'am.
Good morning.
Yes.
Go ahead, go right ahead.
Thank you. Good morning. My name is Marlies Spaniard, and I am the Director of Education Advocacy for the Committee for Public Counsel Services. In that role, I oversee the EdLaw project, which provides education legal services to court-involved children and youth. Our project is specifically set up to disrupt the school-to-prison pipeline. We have unique access to the hundreds of court-appointed attorneys across the state representing children charged with offenses in the juvenile court. Under Chapter 253 of the Acts of 2020, Section 23, the MPTC was explicitly instructed by the legislature to consult attorneys experienced in juvenile law and education law in the development of the course instruction, learning and performance objectives, and curricula and standards for SRO training. Given our unique access to both education law and juvenile law, the EdLaw project would have been an obvious choice for consultation. We have not been consulted, nor has the leadership of the Youth Advocacy Division, the Juvenile Defender Branch of the Committee for Public Counsel Services. We are further unaware that any of our colleagues in the education legal advocacy community have been consulted about the development of the curriculum. We ask that you assist the MTPC to fulfill their requirement to consult with education and juvenile attorneys so that we may share our experience. The attorneys from the Youth Advocacy Division, both staff and private, represent most students arrested in school across the state and have unique insight into some of the current challenges with SRO training and program implementation. We have knowledge and data to share about the disproportionate rate of arrests of students with disabilities and students of color. We know from 2020 juvenile arrest data that in Massachusetts, although Black youth account for just 10% of the population, they account for 30% of arrests, and Hispanic students account for 18% of the population and 30% of the arrests. We also have data from the ACLU that shows that students with disabilities are nearly 3 times more likely to be arrested than students without disabilities. The risk is higher at schools with police. If we are going to have police within our schools, it is imperative that they be trained to understand implicit bias, child development, trauma, and disability-related conduct. We remain open and available for this conversation. Thank you.
Thank you very much, Ms. Spaniard. Thank you very much for your comments. Next, we'll move to Lisa Thoreau from Strategies for Youth. If you're in attendance, please signify that.
Enrique, excuse me,
Go ahead,
if you don't mind, just the
Yep.
previous presenter, if she has any data that she could forward that to the commission of the information that she was providing, those numbers would be helpful.
Thank you, Commissioner. She's no longer a panelist, but I'm hoping that she heard this. But we'll circle back with that with her.
I will contact her via email and make sure that we request that. I have her email.
Yep. Thank you, Commissioner. Once again, I see. Oh, there you are. I see Ms. Thoreau identified. You'll bring her in.
Mm-hmm. She's on the way.
All right. If you can unmute yourself and turn off the video if you desire, Ms. Thoreau.
Good morning. Thank you
Good
very
morning.
much. I want to point out that in addition to the data that Ms. Spaniard could offer, the Office of Child Advocate recently released data that confirms a lot of what she just mentioned. Anyway, good morning. My name is Lisa Thoreau. I'm the Executive Director of Strategies for Youth, an organization that seeks to ensure the best outcomes for youth who interact with law enforcement by promoting the use by officers and law enforcement agencies of developmentally appropriate, trauma-informed, racially equitable policies, practices, and partnerships. Today, I wish to comment on the Mass Post Commission School Resource Officer policies. I want to begin, however, with the restatement of the purpose of a post. As I understand it, as the literature on post commissions describes, the purpose of a standards and training commission for law enforcement serves to first transcend local control and determination of police oversight, 2, create statewide uniform policies and standards, and 3, create systems and mechanisms of accountability. Until 2020, Massachusetts lagged behind 46 other states which have adopted posts to date. The enactment of Chapter 253 of the Acts of 2020 represents a major step forward in regulation of Massachusetts police officers and police departments. For these reasons, SFY strongly supports the establishment of the post and commends the speed with which it has gotten up and running, achieving major milestones even during COVID. Most police accountability mechanisms, like lawsuits filed under Section 93 federal civil rights claims, come into effect after a bad act by an officer. These lawsuits have limited power to change law enforcement policies that are ineffective or harmful, and civilian oversight agencies rarely have the legal authority to fully examine conduct or compel policy changes. For these reasons, we are heartened by the creation of the Massachusetts Post in 2020 because it has the authority to create policy and standards, ensure training requirements are met, and establish hiring criteria that could prevent harm and misconduct before they occur. Because the Post has these powers, it can ensure accountability, build trust, and command deterrence, and thereby ensure greater professionalism of the policing field statewide. In view of the potential for the post to bring about meaningful and important changes to the policing profession in the Commonwealth, we ask the Commission to reconsider 3 key aspects of the SRO certification policies it has circulated. First, when the post certifies school resource officers, it is telling parents, students, and school administrators that officers have met the legal standards for selection, completed training provided by the Municipal Police Training Committee, and understand their obligations pursuant to the state's Memorandum of Understanding between law enforcement agencies and schools, which delimits school resource officers' roles. Certification necessarily requires the post to be aware of the training curricula offered by the MPTC and ensure that the MPTC has complied with its legal obligations to consult with experts and ensure specific performance standards are met when creating this curricula. Until the post can ensure that the MPTC has met its legal obligations, we recommend that the post should not certify officers as equipped and ready to work in the Commonwealth schools. Second, the deployment of SROs is now more regulated in Massachusetts, especially after data indicated the consistent disproportionality and harmful effects of some SROs on youth of color and students with disabilities. As a result, the legislature enacted language for a Memorandum of Understanding, or MOU, that makes clear to law enforcement and schools the limits of officers' roles in schools. We commend the adoption of this MOU for its explicit limitation on schools' ability to ask officers to use their law enforcement authority to serve as disciplinarians. The MOU has prohibited this. In short, this MOU is a public agreement as well as a law, and it's a public commitment to parents and students about how both schools and law enforcement will behave. In view of how few law enforcement agencies in the Commonwealth have explicit policies for officers' interactions with youth inside or outside of school environments, the need for clear guidance and policies is especially necessary. This is why we emphasize the importance of including the MOU. While its existence may appear to have no relation to whether an officer is qualified and should be certified, a school district's adoption of an MOU is a necessary predicate for the placement of an officer. Until the MPTC integrates training on what the MOUs require into its curriculum, and until a school district has adopted an MOU, we recommend the post not certify officers to work in public schools. Third, our concern with the SRO certification application to be completed by law enforcement chiefs should more closely follow best practices and track the existing legislative requirements for identifying, hiring, and assessing persons most qualified to be SROs. This is an oversight in the proposed policy that we think can be very easily fixed, but we urge you to consider how critically important it is, because not all officers are well suited to work in school environments, and many do not want to. For too long, being an SRO was either considered a plum position available only through seniority for those who wanted a certain schedule, or it was considered a dumping ground for officers. Consideration of which characteristics officers should bring to this position, including past experience working with youth or post-secondary school education in child and adolescent development, have heretofore been immaterial. The Commission needs to change this approach by clarifying what characteristics chiefs should look for when recruiting officers who will interact on a daily basis with youth in an educational environment. And the Commission can just list the qualities highlighted in the statute under Chapter 71, Section 37P, and look to publications issued by the US DOJ, US Department of Ed, and the Community-Oriented Policing Services for guidance. In conclusion, now more than ever, the public and students want reassurance that officers in their children's schools are skilled, equipped, and guided by clear policies by which they will also be held accountable. Because the role of the post is key to establishing a professionalism and oversight, and because certification is Massachusetts' endorsement of an officer's capacity to serve professionally, we urge the post to consider making these changes to the SRO certification policy. Thank you for considering our recommendations, and I will submit this statement along with the other statement we have submitted October 27th. Thank you.
Thank you very much, Ms. Thoreau, for those thoughtful comments. Let me see. Let's go back to the list. Jamie, I have Matt Kreger. Again, I'm sorry if I'm mispronouncing your name, sir, but if you can raise your hand in the function at the bottom of your screen, that might be the person, Zoom 3. Jamie, is that?
I'm assuming that's it. I cannot find him by name, so I am going to admit that person, yes.
Okay, let's admit Zoom 3 M.G.L, the way they signed into Zoom. And hope that's Mike Kreger. You can unmute yourself. There you are.
Yes, can everybody hear me?
Yes, go ahead.
Thank you, appreciate it. Matt Kreger, staff attorney at the Mental Health Legal Advisors Committee. We're a state agency under the Supreme Judicial Court dedicated to protecting and advancing the rights of those with mental health needs. It's from that perspective and the work we do on behalf of students with mental and/or behavioral health needs that I come to offer these comments to you today. We see a critical need for robust regulation in this area and are grateful to the Commission for this effort. To be clear, I'm going to speak not only as an attorney, but as a public school parent in Boston and as a former New York City Bronx public school teacher. Right? We all want children to feel safe in schools, for adults to feel safe in schools. We don't think kids can learn if they don't feel safe, but we are scared by the way that we have turned to police to fill that need, because for many of our youth, if they've had negative experiences with police in their communities, right, have felt targeted by police in their communities, have seen it happen to their friends or their family, right, that can be a re-traumatizing experience to see it in schools. And even worse, if you were like me, a first-year teacher who was never trained in how to handle classroom management, it's all too easy to defer to the school resource officer to become not an officer, but the default disciplinarian. And the great danger there is that very quickly, a matter that could have been handled with a call home gets handled with a call to the police. And we all know that a first-time arrest doubles the odds that a student drops out of school. A first-time court appearance quadruples them. So we have a very volatile situation that we introduce our police into when we're asking them to keep our children safe. And if that's going to ever work, it's going to be because those roles are delineated as clearly as possible. And one thing that is absolutely necessary for that to happen is for the document that you have in front of you to be explicit about what these SROs need to be trained on. Right? And to us, that's several things. One is the document should reflect training on the model MOU that our state has adopted. In the police reforms of 2020, the legislature said, we need a model MOU that will become mandatory for any school district that has school resource officers. It becomes the floor. A district could add more rights, more protections, more embellishments, but it can't take away from the protections that are here. And that MOU is very specific in admittedly legal jargon about what sort of situations an SRO can get involved in. And the danger with that specificity, but a lack of training on it, is that we're putting an officer in a situation where they have to respond in real time, not just to what a student is doing in front of them, but to what a principal may be asking them to do, or what a teacher may be yelling at them to do, or what an adult or student may be propelling them to do. We have to make sure our officers and our administrators are all on the exact same page about what it is they can be engaged in. And without specifying that training, we're leaving our officers and our schools, and as a result, most importantly, our students at a disadvantage. So the regulations must explicitly train, must call for explicit pre-service and in-service training on what is in this MOU and the standard for when it is that an officer can get involved in a school situation. Similarly, the legislature has done us a favor by being explicit about several things that officers must receive training on, yet to date, We've not seen any documents from the MPTC that would suggest that this training is happening according to statutory requirement. So the provisions in section 116 delineate exactly the topics that an SRO must be trained on. And we think that the regulations should simply reflect that. That way, everybody's on the same page at the same time about what it is that SROs are going to need for in-service training and to qualify for certification in the first place. Right? Finally, in hearing Ms. Thoreau's comments, I agree. Right? This is not the first time that the state has required MOUs to exist between school districts and local law enforcement agencies. And it's often taken years for our law enforcement agencies and school districts to adopt the MOUs that state law requires of them. Unless it's done something recently, my own children's school district of Boston is still using an MOU from the 1990s. With that in mind, it's really important that we take Ms. Thoreau's advice and limit the certification of officers to those in school districts or serving jurisdictions where that MOU is already in place. And finally, while I was grateful to see language about the prospect of revocation or suspension or non-renewal of a school resource officer's certification as an SRO, I didn't see specifics beyond training that would warrant that. And I'd like to turn the commission's attention toward the model MOU once again, because in it, the model MOU calls for a need for annual review of school resource officers that's led by our superintendents and our chiefs of police, and incorporates factors like a limitation on the unnecessary use of arrests or referrals to law enforcement where they're not necessary. And similarly, an incorporation of the voices of all of the school community in making sense of how that SRO is doing their job. And that means parents and students, but it also means teachers and principals who are all a part of that building and have to exist together. So if we're going to place officers into the combustible situation that is education, right? That is where students are learning not just academically, but how to comport themselves as a part of a building, as a part of a community, and how to learn how to model and adapt the behaviors that are going to be necessary for them to exist in society. We have to draw lines that are going to make it clear that we're not responding to childhood behavior with an aggressive law enforcement response. And unless these regulations reflect that, which is a principle of state law, unless these regulations reflect that, we're doing a disservice to everybody who has to exist in those buildings together. Thank you for your time.
Thank you very much, Mr. Kreger, for your thoughtful comments. Next, I have Attorney Rebecca Jacobstein from CPCS. There you are. Thank you for identifying yourself. Jamie will bring her in. Maybe you can, unmute yourself, and there you are.
Oh, here I am.
Yes.
Thank you. Good morning. My name is Rebecca Jacobstein, and I work for the Committee for Public Counsel Services. We believe that the Post Commission is in a powerful and unique position to bolster public confidence in law enforcement. The best way the Commission can foster public confidence is through transparency and accountability. Unfortunately, the regulations as they are currently written will undermine this goal. We hope you will consider our concerns as you finalize these important regulations. We would like to discuss 4 overarching concerns today. First, the regulations codify unreasonable prolonged delays in disclosure. Second, the regulations permit permanent exclusion of information that the public has a right to know. Third, aspects of the regulations are vague and overbroad, which will enable the abuse of discretion. And fourth, the regulations contradict and undermine the public records law. First, 803 defines conclusion of a matter as to the point when there is no opportunity for review by any court or agency. This is overbroad and over-inclusive. Matters in the court system can take years to conclude. Since sections of the regulations such as 8056A9 exclude disclosure of information before a matter reaches its conclusion, there will be years-long delays in disclosure. Instead, conclusion should mean when the post-commission has rendered its ultimate decision on a matter. The commission should be equipped to investigate misconduct, make findings, and ensure officers receive due process. To withhold information even after the commission has made its final decision undermines trust in law enforcement by suppressing potentially powerful information about misconduct for years, and it shields the post-commission decision-making from oversight. Second, there are multiple sections of the regulations that explicitly enable exclusion of information that the public has a right to know. The post-commission collects information about officers who have been convicted of felonies, but under 8055D will not disclose these convictions in their database, erroneously citing to the Corey Law. The Supreme Judicial Court has repeatedly emphasized that the Corey Law does not prohibit disclosure of public official misconduct. The commission also collects assessments regarding whether police officers have good moral character. But under 8056A5, the post-commission states it will be concealing this information as well. This is unacceptable. Not only does the public have a strong interest in knowing which officers were deemed to be of good moral character or not deemed to be of good moral character, the public also has a strong interest in knowing whether this commission has decided to certify them anyway. The proposed regulations shield both law enforcement officials and this commission from scrutiny. In addition, 8054A10 withholds unsustained and unfounded complaints, regardless for the reason of these conclusions or the underlying nature of the matter. There are police departments that do not have robust internal investigation units, and they regularly deem complaints unsustained. If an officer has a history of complaints, whether sustained or not, that pattern can be important. Third, sections of the regulations are vague and appear to authorize alarming non-disclosure and expungement practices. 8055R precludes disclosure of private information, but does not clarify what records that may pertain to and whether the result will be wholesale withholding of records or reasonable redaction of private information. 8056D and E forbid disclosure of records an individual has the right to correct or expunge without specifying what that includes or excludes. Based on prior communications from the commission, the commission's general counsel, the commission's interpretation appears to deny disclosure of misconduct investigation records. Fourth, the regulations contradict and appear in some instances to even violate the public records law, which clearly and deliberately states that a presumption shall exist that each record sought is public, and the burden shall be on the defendant agency or municipality to prove that such record may be withheld. Of course, the post-commission does not have the authority to promulgate regulations interpreting the public records law. But putting that aside, we wanted to emphasize the following concern. First, 8062 makes segregation and redaction optional and contingent on what the commission believes is feasible. Segregating and redacting exempt materials so that remaining records can be disclosed is not discretionary. It is required. Second, the regulations include impermissible blanket non-disclosure practices. For example, 8056A9 conceals any disciplinary matter that has not reached a conclusion, whereas General Law, Chapter 4, Section 726F requires the balancing of investigatory prejudice and public interest in disclosure on a case-by-case basis. Third, 808(3) and 4 allow the commission to force individual law enforcement agencies to coordinate their public record request responses with the commission. This glaring attempt by the commission to gatekeep access to public records undermines the public records law. Fourth and finally, 8.0112 mandates maximum payment of fees to receive records substantially similar to those in the forthcoming public database. Given the many concerns we outline above about records the commission plans to exclude from its public database, it is easy to imagine a great deal of records detailing police misconduct will trigger this provision. The regulation seemingly exists to suppress access to records of vital public information, vital public importance the commission does not want to share through exorbitant fees. The legislature entrusted the commission with a mandate of ensuring transparency and accountability when law enforcement officers commit misconduct. We believe these regulations hinder and at times outright flout this directive. We hope the Post Commission carefully considers our feedback as it embarks on fulfilling its mandate, so we can achieve our shared goals of transparency and accountability in law enforcement. Thank you.
Thank you, Ms. Jacobstein. Thank you for your thoughtful comments. Next, we have Leon Smith from Citizens for Juvenile Justice. I think he's right there. There you are.
Good morning.
Yes, good morning. Go right ahead, sir.
My name is Leon Smith, and I'm the Executive Director of Citizens for Juvenile Justice, an independent statewide nonprofit organization that works to reform and reimagine the Commonwealth's juvenile justice and other youth-serving systems. My comments this morning are shaped by my experience as a legislative appointee to the Commonwealth's Model School Resource Officer Memorandum of Understanding Review Commission, which was created by the same law as the Post and charged with creating a statewide MOU that serves as the minimum requirement for schools and police to formalize their partnership around the placement of SROs. This commission had the legislative charge to determine the necessary provisions to achieve the district's educational and school safety goals and to help maintain a positive school environment for all students. Based upon this experience, I must express concern that the draft regulations currently proposed run the risk of undermining the requirements in the statute setting forth the minimum requirements for the assignment of SROs in our schools, and I respectfully offer several important additions to the draft regulations. First, the draft regulations must reiterate the requirements of our general laws that SROs not be involved in school discipline matters, enforce school regulations, or act as counselors. Currently, the proposed regulations only vaguely reference maintaining positive school climate, but it excludes the clear parameters in Chapter 71, Section 37P, subsection B, mandating that school resource officers shall not serve as school disciplinarians, enforcers of school regulations, or in place of licensed school psychologists, psychiatrists, or counselors. Nor should they use police powers to address traditional school discipline issues, including nonviolent disruptive behavior. The legislature found this restriction crucial enough that they required this exact language to be included in the model SRO MOU. And similarly, this language must be included in the regulations here to ensure that SROs are clear on this core restriction on their role. Secondly, the draft regulations omit the requirement for a law enforcement agency to submit an approved MOU and standard operating procedures. And that's problematic and risks subverting the intent of the MOU legislation under that same statute, Chapter 71, Section 37P. It's really imperative that post-certification requirements for SROs and the statutory requirements for the model SRO MOU are harmonized to create a common and consistent standard governing the roles and responsibilities of SROs in our schools. This includes the absolute necessity of ensuring that each district has the model SRO MOU adopted and implemented, and that any SRO seeking certification ultimately be trained on the provisions in that model SRO MOU. If an MOU is not in place and SROs are not trained on its terms, we run the risk of an SRO being put in the unfortunate position of being certified and placed in a school without guidance on their role, responsibilities, and standards governing the permissible interaction with students. Therefore, I respectfully request that these regulations explicitly state that if an officer is certified as an SRO, appointment to the school district is ultimately contingent on that district and local police department having a finalized MOU between the school district and the police department, and adopted standard operating procedures that meet the minimum requirements of the model SRO MOU and the legal requirements of Chapter 71, Section 37P. And finally, the post regulations must also include a section detailing the impact that formal complaints and any adverse findings have on an SRO certification. The state's model MOU has a section that mandates a simple and objective complaint resolution process for all members of the school community to register concerns that may arise with respect to the SRO. Now, the requirement of this system was included to ensure that there were formal avenues for anyone in the school community, but specifically parents and guardians, to submit any complaints they had about the SRO, and to ensure that these complaints were handled in a timely manner, including communication of the resolution to the complaints. Given this required implementation of a complaint process as a part of the SRO MOU, in order to, again, harmonize requirements, we believe that the post should create protocols for the timely sharing of these same complaints where an SRO is found to be out of compliance with the SRO MOU or state law, or is otherwise engaging in conduct that is unsuitable or unbecoming of the position, and for the post to be able to then determine any appropriate impact on certification. We also believe there should be an SRO specific threshold established, which allows an officer to remain on the police force, but no longer be authorized to serve as an SRO based upon any complaints of non-compliance or misconduct that are revealed and validated through these complaints. And again, I respectfully, list these recommendations to ensure that SRO presence has a positive impact without any of the harm driving students into the school to prison pipeline that some of my colleagues have mentioned earlier. Thank you so much for your time and the opportunity to speak this morning.
Thank you very much for your comments, Mr. Smith. Thank you again. All right, next we have David Walker, also from Strategies for Youth. There you are.
Okay, thank you. My name is David Walker. I'm the Director of Training for Strategies for Youth. Lisa Thoreau spoke about what our mission is earlier. And I'd like to raise two concerns about the proposed regulations, if I may. Our first concern is that the post promulgation of policies for certifying school resource officers, we believe deserves another review. We know that the post must rely on the Municipal Police Training Committee, or the MPTC, which is charged with providing the training of SROs. Unfortunately, it appears that the MPTC has not developed and implemented robust, consistent, and evidence-based training to ensure that the Massachusetts school resource officers are prepared to work in the Commonwealth schools in accordance with legislative requirements and the state's law regarding implementation of a memorandum of understanding between law enforcement agencies and the schools. Why this is a concern is that the post is in the position to certify SROs as ready to be placed in schools. To do so, it must proceed on the assumption that the MPTC has properly trained officers that the post then can certify. This is essential to protecting the students SROs serve, as well as reducing the exposure of school administrations, law enforcement agencies, and the Commonwealth to litigation for improper and potentially harmful interactions with students. This is of special importance for children of color and children with learning and behavioral disabilities who are entitled to state and federal protection under special education laws. We believe the solution should be that the post's role in certifying the preparedness of SROs should depend predominantly on certifying that officers completed a course based upon an MPTC training curriculum. The post must therefore be able to coordinate with the MPTC and ensure that the MPTC's legislative mandate has been met to ensure officers are prepared and equipped according to those mandates. Presently, in view of the lack of certainty that the MPTC has offered, the post cannot certify that officers are prepared and ready. The law of the Commonwealth requires that the MPTC's course of instruction for SROs, the learning and performance objectives, and the curriculum and standards for training developed pursuant to this section shall be developed in consultation with experts on child and adolescent development, on child trauma, and with educators and attorneys experienced in juvenile and education law and preventing and addressing youth hate crimes. It also appears to be the case that the state's model MOU must be part of the training, as the purpose of the MOU is to describe the role of the SRO and the legal and policy obligations they must follow in an educational environment. Until the MPTC can guarantee the post that it has taken the following 3 steps required by state law, the post should not certify SROs as prepared. And we believe those steps are: first, to develop a performance standards rubric for school resource officers; 2, provide an opportunity for public review and comment on a performance standards rubric; and 3, ensure inclusion of relevant laws, including the law requiring adoption of MOUs. Our second concern, we want to offer recommendations here to ensure that the post can give chiefs support and guidance in choosing officers most suited to become SROs. The current language regarding the selection of SROs leaves this decision to each chief, as has been mentioned by other folks in this call. SFY suggests consideration of specific features that, in our experience, lead to the deployment of officers best suited to working with youth in the school context. Historically, the deployment of officers to the position of SRO has been determined by seniority, union rules, schedules, and sometimes a decision to simply place officers who could not be placed elsewhere. This has often led to officers uninterested in working with youth, which has in turn led to bad outcomes for youth. We recommend offering a selection criteria rubric for officers working in a school environment, using the criteria set forth by the U.S. Department of Education, as well as other organizations. The post's efforts to further define who should be considered for the SRO position will serve chiefs, officers, and schools well if review of these useful criteria is considered at the outset of the selection process. For law enforcement officers who are already working in school environments, encouraging chiefs to use a selection rubric and consider their fit for the school environment may also be useful in determining whether to keep officers in place or to reassign them. We also suggest creating a review board to enforce adherence to the selection criteria and the performance standards as adopted by the Commonwealth. We do have recommendations for what we believe a school resource officer selection rubric should consist of. Similar to what has been commented before, some of those selection rubric items would be to have no disciplinary actions on their file, to be commissioned as a qualified law enforcement officer, and also to have demonstrated ability to teach and engage with youth, such as past coaching or mentoring experiences. We will be submitting our comments together with the rest of the suggestions for the selection rubric in writing at the conclusion of my testimony. And thank you very much. I appreciate the time.
Thank you, Mr. Walker. We appreciate your comments and welcome your written testimony as well, very much. Okay, I just want to announce that there's a couple of people who have identified themselves as wanting to speak just today. We have one more person who signed up in advance. I'm going to get to them after I call on the following person, Jay Blitzman, who signed up in advance. I see him there. He'll be coming in a minute, and we'll get to people who identified themselves today in just after Mr. Blitzman. If you can bring in Mr. Blitzman, Jamie. You can unmute yourself, Mr. Blitzman. There you are.
Good morning.
Good morning. Go right ahead, sir.
Thank you for the opportunity to appear and to offer my comments. First of all, I'm a retired juvenile court judge. I served for 24 years as a juvenile court judge. The majority of the time as the first justice in Middlesex County Juvenile Court, sitting primarily in Lowell. Prior to that, I was a public defender for 20 years, and I worked with others in creating the statewide youth advocacy division. My current role is as the interim executive director of Massachusetts Advocates for Children. And I think this current position is particularly relevant, not that the other experiences were not, in the conversations we were having this morning. I say that because MAC's mission is dedicated to removing educational obstacles facing children in all contexts. This includes addressing issues of disparate school discipline, as well as the intersection regarding disabilities and race. Some of you may be aware of the recent Globe report concerning dramatic disparities of treatment of youth with disabilities in the Boston public school system. I had prepared written testimony, but having comments rather, but having heard comments of preceding speakers, I'm going to go off script. I will say, as a prefatory matter, my feelings and comments are very, very much aligned with some of the prior speakers, including Leon Smith, the executive director of CFJJ, Matt Kreger, and Lisa Thoreau-Gray, and I'll amplify. I want to begin by just stating the obvious. We have to remember the historical context that led to your creation, to the post creation. In this state, we had legislation in 2018, robust criminal justice reform, part of which required school districts to create MOUs, memorandum of understanding, regarding the interaction of educators and police. Central to that mission, and this has been a key factor that endures today, is the need to specify the line between normative adolescent behavior, which should be solely within the province of educators, and more palpable conduct which justifies police intervention. So the mantra of counselors, not cops, is more than a mantra. It's incredibly important. It's not a question of good police or bad police. It's a question of what do we really want to have for our children in promoting safe, supportive school environments. And the data is robust that in spite of good intention, often the deployment and placement of school resources, especially when they're in significant numbers, adversely has resulted in placing these officers in schools of color. Schools which have never had a school shooting, schools which have really not had palpable concerns about school safety. So, Mr. Ellison, you mentioned the need, or you're interested in looking at data. So I'm going to quote from an article which was published in July of 2020, a mega-analysis entitled "Effects of School Resource Officers on School Crime and Responses to School Crime," which indicates that in comparing schools utilizing police and schools with those that do not, the presence of school police increased the likelihood of school arrests, especially as regards special education students. I underline that given my current role at MAC, and recommended that educators seeking to improve school climates pursue alternatives. This recommendation aligns with the Dignity in Schools campaign, which focused on promoting strength-based alternatives to zero tolerance, such as restorative justice, positive social learning, and counseling. It's a sad reality that millions of our students today attend schools that have armed police but don't even have guidance counselors. Why is that? Where is the need? During the course of my tenure as a judge, I spent many, many years working with very well-intentioned police and coming up with memorandum of understanding designed to address these very issues. What is the line? What is the demarcation between normative adolescence and childhood and more egregious or serious conduct that justified police intervention? Unfortunately, while the post, excuse me, and then again, from the historical perspective, the tragic death of George Floyd led to a national rethinking of police in all contexts. It led to the 2020 police reforms. It led to the SRO Commission. My concern in looking at these draft regulations is that we're taking, unfortunately, significant steps back. Not only is the, as noted by some other speakers, the MPTC training curricula has not evidenced fidelity to what was intended in the 2018 legislation or the 2020 SRO Commission. What's singularly missing in the draft regulations, CMR 10.04, is which alludes to maintaining positive school climate, there's no clear articulation of the imperative of expressly stating that police should serve should not serve as school disciplinarians, and police power should be limited. The speaker from Worcester underlined this reality of what happens when you have police control the schools. A 2012 study, to cite another study called Arrested Futures, looking at the patterns of school discipline and policing in the state's 3 largest schools, note that when police are in charge or have unfettered discretion without an MOU and are operating independently in school, the results for students are very, very, very adverse. So I would urge you as a group to really look at this issue in addition to addressing issues of safety through a lens of racial and ethnic equity. The unintended consequences, well-intended perhaps, of deploying police without demanding, requiring fidelity to the type of training and certification that others have addressed this morning, I think will result in very foreseeable and negative consequences, and unfortunately will result in criminalizing adolescents and children. And I just want to conclude by saying, you know, I alluded to my experience working on MOUs. I've worked with the Juvenile Detention Alternative Initiative, a national initiative funded by Annie E. Casey. I've toured the country with police officers talking about model MOUs, with the National Council of Juvenile Family Court Judges. I created Lowell School court meetings to address these issues. Please, good intention does not suffice. The draft regulations are very, very, very vague and do not address the MOU requirements. They do not address what's really required in certification of an officer before they assume the significant responsibility of patrolling school corridors. If we're going to have police in schools, if that's the collective wisdom, let's really be thoughtful. Let's not go down the path of exacerbating racial and ethnic inequity and criminalizing children and youth. So thank you for the opportunity to share these observations.
Thank you, Judge Blitzman. And we'll also take your written comments if you had them and intended to get to anything that you.
I'll be glad to send you the data that I alluded to, the Arrested Futures report and the July 2020 mega data analysis, because the data is really clear what happens if we don't really address the detail that's necessary. Thank you.
Thank you. Okay, I think in order of people who identify themselves in the Q&A function, I have Laureen Spies, I think. I know her, and I don't know how to pronounce her name now, from McLeod. Laureen, if you are in attendance and want to, yes, there you are. Are you bringing her in? There you are. if you want to unmute yourself. And
Thank you.
we can hear you. You're welcome to, oh, there you are.
Good morning. Thank
Good
you.
morning,
Sorry
Maureen.
about the technical difficulties. I
No, no,
appreciate
that's okay.
I appreciate the opportunity to speak to you. I'll keep it very brief. There's just two things in the that we wanted to talk about dissemination information. Under section 8.05, under public database, section C, it talks about public employees and their family members and their personal information not being disclosed. And we respectfully ask that the language from 805 section 1 be used, where it talks about all different officers that are certified, conditionally certified, or show certifications under pending, restricted, limited, or suspended, and officers who have been decertified or not recertified. And the reason why we ask that is any other officer that's post-certified or in the process or decertified, they're not listed there, so I'm not sure that they would be covered for their personal information not to be disclosed, because currently it's only talking about public employees. And then the second section that we'd like to request language change is section 8.07 under objections concerning data. Currently, it's still, it talks about public employees again. It says that the commission shall maintain a public database of information. What we'd like to see is the language from section 1 in 8.05, again, talking about all officers, whether they're certified, decertified, in the process, pending, instead of using the words public employees, because we want to make sure that all officers that fall under post are afforded the same rights as and opportunities as public employees. And so I did send an email last night with the language changes that we respectfully request. And, it's a concern because we want to make sure that anybody who is a police officer in this state and falls under post doesn't have their information disseminated. And also if they have the right to appeal within their agency and post, that they have that opportunity as well. So thank you very much for your time this morning.
Thank you very much. Thank you for your thoughtful comments. Okay, next, I had seen Dennis Galvin, who had raised his hand previously. There you are. You can be let in by Jamie in a minute. Please unmute yours. There you are. Go ahead, sir.
Thank you very much for the opportunity to address you. My name is Dennis Galvin, and I am the president of the Massachusetts Association for Professional Law Enforcement. We're an organization that is dedicated to we're made up of former police officers, retired police officers, current officers, and criminal justice educators, both retired and active. Our concern is the image and the effectiveness of today's policing. And our goal is to try to elevate the police service to the level of a profession, and through basically education, ethics, and improving accountability. So I myself am a retired major of the Massachusetts State Police. I've had over 30 years of experience in policing, and I wanted the opportunity to make a few comments on this. First of all, I'd like to just say open by saying that there's two concerns here. Number one, school violence is, unfortunately, in some parts of our society, a real and current threat. I think one of the most interesting examples of it was the findings on the school at Mission Hill in Boston, as far as the conduct. Obviously, some of this violence and some of the disruption is directly impacting and affecting the mission of education. And the children have a right to have an environment in which they can learn and grow without fear and in peace. That being said, there is also a lot of concern being expressed about the conduct and lack of confidence in the police, which is not at all, and we would say that it's not all unjustified. All right. SRO position would be a very specialized position requiring exceptional scrutiny, and we would agree with those who have said that it would require a high level of suitability. I think that's the key. That's a very important word to remember, is the issue of suitability. I was impressed with comments from Leon Smith and from David Walker. I think they offered some very incisive and very relevant comments that I think that the committee should follow. I would say that what I would ask I think Mabel would ask the Post Commission to consider here is the fact that you're getting evidence that policing is now evolving from what many people have perceived it to be as basically just order maintenance. It's a little bit more involved than this. And we would first of all ask you to maybe reconsider your earlier decision not to include some level of higher education as a police requirement for selection. I think the original one was 2-year degree. I think that's something that's relevant. You should reconsider that. And specifically with regards to the provision of people who are being selected for the position of SRO, it's a critical position. We think that higher education is a very important aspect of this and should be included in the requirements at some level, whether it's associate's degree or ideally bachelor's degree. And we have to also be realistic about how fast the MPTC can come up to speed for the demand that you're putting on it with regards to the level of quality and the level of complexity that they're going to be trained. I'm not sure whether they're able at this point to gear up that fast to provide that high academic level of training, which would be required for a position, I think, to be an effective SRO. So we simply wanted to, share those with you, and also and just also leave you with this particular final thought, and that is on the question of disclosure. We understand that transparency is an important part of police reform. We understand it's a concern of most people. We just ask you to be very sensitive to the fact that policing oftentimes operates in a very dangerous adversarial environment, and there is this issue of safety at stake, and we would ask you to always please keep that in mind. Thank you very much for your time.
Sorry, thank you, Major Galvin. I appreciate that, your comments, as all others. Okay, I think that's as far as we had in people who signed up to speak. Are there anybody in attendance at this point who would like to offer any comments? Anybody in attendance is more than welcome to do so. If you wish, please signify that by clicking on the raise hand function. You could also submit a question via the Q&A function at the bottom of your screen. And we'll bring you in if you desire to do so. I see a couple of people attending by phone. If you are attending by phone and want to offer oral testimony, please remember to click *9, and that will enable you to be identified, and you may also provide oral testimony by phone. Once again, we are conducting a public hearing of two sets of proposed regulations at the Post Commission. One set of regulations deals with the dissemination of information of law enforcement officers. And the second set of regulations deals with the school resource officers certification. Anybody we've been accepting oral testimony throughout the morning, and we thank you all of those who have participated and providing them in writing. If there are additional attendees at this time who would like to offer oral testimony, please signify that by raising your hand, clicking raise hand at the bottom of your screen, or submitting a question in the Q&A function also at the bottom of your screen. We are scheduled to be here until 12 o'clock. And I see that there's a few members of the public in attendance. I want to make sure that anybody who wants to speak has an opportunity to do so. So please, again, identify yourself if you wish to do that. Or if you're dialing by phone, you can hit *9. I see a member of those in attendance ask the question that I'd like to answer. It says, do you have the next post-commission meeting date where the commissioners will discuss the feedback received during this public comment period? And I can say that there is, we'll be scheduling a public meeting this coming Tuesday. That would be Tuesday, December 13. We have not finalized the agenda. We can post the agenda 48 hours in advance, unlike we usually do. And my intention, of course, is to provide at a minimum a summary of the comments received today and in writing. We'll likely also be including all the written comments that we received up until 5 o'clock this morning in the commissioner's packet and available in our website, as is always our practice. I hope that answers your question, sir or madam. Thank you for your question. Once again, we are conducting a public hearing on the proposed regulations. As noted, that dissemination of information about law enforcement officers as well as the school resource officer regulations, proposed regulations. If you want to provide oral testimony at this point, please signify your intention to do that by raising your hand, and you will be able to comment on those proposed regulations. You can also do that by asking a question in the or identifying yourself in the Q&A function at the bottom of your screen. I see another question. I've noted that this is not a question and answer period, but I'm inclined to answer it. It says, will written comments be accessible by the public? And the answer is yes. I just don't know exactly at what time, but we will make all the written comments eventually accessible to the public once we are able to incorporate all of them together. We will be receiving and accepting rather public written testimony until 5 o'clock today. So if you are inclined or have not already done so, please keep in mind that time frame. We're accepting written testimony until 5 o'clock today. The instructions are in our website, and we hope that you're able to find those. Once again, we are conducting a public hearing on proposed regulations for the Post Commission. Those are regulations on the dissemination of information of police officers and certification of school resource officers. We've heard thoughtful commentary this morning and testimony. We appreciate all of those who have provided that. We'll be receiving and accepting written testimony until 5 o'clock today. If you haven't already, please submit your written testimony as indicated in our website. I see the list of attendees has slowly been decreasing. Again, we appreciate your attendance. If you're still in our audience and would like to offer oral testimony, we encourage you to do that. Please signify your intention by raising your hand, which is clicking on the raise hand function at the bottom of your screen, or submitting a question or statement to that effect in the Q&A function. Both functions are enabled to anybody in attendance to this webinar. Is there anyone in attendance still who would like to offer oral testimony at this time? Okay, I see one person. Jamie, somebody has identified themselves. Anne-Marie G.
Anne-Marie Grant, for the record, private citizen. My brother Thomas Purdy was 38 years old when he was hogtied and asphyxiated to death by police in Nevada. He was a Massachusetts resident at the time he was murdered by police. I'd like to comment in regards to the database and dissemination regulations. All information regarding complaints, investigation, and results should be released to the public. For far too long, the bad acts have not seen the light of day. Transparency and accountability is what is desired from the community. These regulations are weak and watered down. It feels as though governmental entities, which are frequently interacting with the public and who carry out consequential actions, are the least transparent. It needs to be the exact opposite. Releasing all relevant post-investigations will increase public perception and public trust. The idea that releasing an unfounded complaint is not fair to the officer. My response is they do it to community members every single day who have been arrested yet not convicted of a crime by placing their photos on social media and blasting what they've been arrested for, what charges they're facing. I want to thank all of the educators and others who joined this meeting today to advocate for our youth and our communities. You've heard from educators and other members of the community. I'm of the opinion that police do not belong in schools at all. Officers patrolling our children's school hallways represent more of a threat than a form of protection. Armed police officers prohibit many students and staff from feeling fully safe. If we are going to place SROs in schools, they need to be trained properly and have proper guidelines as well as consequences outlined in a signed MOU. Some teachers and students, African Americans in particular, say they consider officers on campus a danger rather than a protection against everything from fights to drug use to mass shootings. There have been no shortage of incidents making headlines across the country, including in Orange County, Florida. A school resource officer was fired after a video showed him grasping a middle school student's hair and yanking her head back during an arrest after students fought near school grounds. An officer assigned to a school in North Carolina repeatedly slammed an 11-year-old boy to the ground on video. The presence of officers in hallways has a profound impact on students of color and those with disability who, according to several analyses and studies, are more likely to be harshly punished for ordinary misbehavior. How about removing police from schools completely, replacing them with a plentiful team of guidance counselors and social workers? It will be intuitive to hire psychologists to provide counseling and nurses to advise students on drugs and alcohol instead of relying on police officers at all. Money spent on SROs should be reallocated to mental health services to treat the root cause of student behavioral problems. Use your opportunity to be on the right side of history and digest and act upon the input you have been provided with today from the community. To the comment that policing is a constant danger and adversarial role, The truth is, far more community members have died at the hands of police, including children, than law enforcement killed by community members. Thank you.
Thank you, Ms. Grant, for your thoughtful comments. We appreciate them. Is there anyone else who would like to offer oral testimony at this time? Once again, we are conducting a public hearing on proposed regulations regarding the dissemination of information for law enforcement officers and the certification of school resource officers. If you are a member in attendance at this public hearing and would like to offer oral testimony, please signify your intention to do that by clicking on the raise hand function or submitting a statement to that effect in the Q&A function at the bottom of your screen. If you are attending by phone and would like to offer oral testimony, you may do so by clicking *9, and we'll be able to hear you. As a reminder, we will continue to take written testimony until 5 o'clock this afternoon, and the instructions are available in our website. Submitting comments to postc-comments@mass.gov. I've seen the attendance list slowly but steadily decrease. We are, as I mentioned, scheduled to be here until 12 o'clock. If there are no more people who would like to speak at this point, I'm inclined to temporarily suspend this hearing, and we'll be back at 11:50, a few minutes before our scheduled end time of 12 o'clock. We'll take a short break and come back at 11:50 and offer some closing remarks. Seeing no other individual who would like to speak at this point, I'm going to go ahead and temporarily suspend this this hearing. We'll be back at 11:50. Good morning again. We are back from the short break. Once again, for those in attendance, we are conducting a public hearing of the Post Commission on two sets of proposed regulations. That is the regulations governing the dissemination of information about law enforcement officers, and the second set of regulations, the ones governing the certification of school resource officers. We've been accepting oral testimony this morning. Thank you for all of those who have provided that, who are still in attendance. If there are any members of the public currently in attendance who would like to provide oral testimony, please signify your intention to do so by raising your hand or submitting a statement to that effect in the Q&A function at the bottom of your screen. Those are the Q&A or the raise hand function. If you are attending by phone and would like to offer oral testimony, please identify yourself by clicking *9 on your phone, which will enable you to speak. As I have stated before, we are accepting and have been accepting written testimony from the time that we first made available these proposed regulations 30 days ago. We will continue to accept written testimony until 5 o'clock this afternoon. And given some of the questions that we received this morning, we'll ensure, of course, and as is our practice, that the rest of the commissioners see the testimony that has been provided, and that testimony, written testimony, is also available for the public to see, somehow available through our website or at the commission packet in the next commission meeting, or both. I will reiterate the way to submit written testimony until 5 o'clock this afternoon, is by sending an email to postc-comments@mass.gov. This information is also available in our website. Once again, we've been conducting a hearing of the Post Commission on proposed regulations. We are approaching our scheduled time to be here. I still see some, I see some members still in attendance. I would like to call on one last time, anybody in attendance who would like to provide oral testimony at this point, please signify your intention to do that by clicking on the raise hand function or Q&A function at the bottom of your screen. If you would like to provide testimony, now would be the time to do so. Seeing none, let me say that on behalf of the Post Commission, I would like to thank all of you for participating in the regulation process. The public comment period is integral to the establishment of proposed and effective regulations. Following the conclusion of this hearing and at the period for submitting written comments, which I have stipulated before is 5 o'clock this afternoon. After that, we will carefully consider the oral and written comments that have been offered. We anticipate that the proposed regulations will be discussed again at one or more duly noticed public meetings of the Commission. If the Commission decides to adopt the regulations, they will be published in the Massachusetts Register, at which point they will become effective. As a reminder, we will be accepting written testimony up until 5 o'clock this afternoon. And the way to do that is by sending an email to postc-comments@mass.gov. Seeing that we're approaching the time schedule for this hearing, I'm going to go ahead. Thank you once again for attending. Thank you for your testimony, and I'm going to suspend this hearing. Thanks again.